Hi, my name is Wilson Pun. I've been a real estate attorney for over 10 years now, and I've helped hundreds of clients close on real estate properties in New York. So typically, I think it first comes down to the intention of the purchase of the property. So whether you're buying the property to primarily live there yourself, or if you're buying it as an investment property. So banks will also take a look at this in both ways. One is owner-occupied versus an investment property. If you're buying it to live there yourself, typically it's going to be whoever's living there, their individual name. So either an individual person or a couple, as in like a husband and wife. So really, if it's residential, you're on the contract, it's just going to be the name of the individuals that plan on living there. If you're looking to buy the property as an investment property, then while you can also still put the property in your own individual name, you have the option of also creating, for example, an LLC or a corporation to become the owner of the property. And if you already have that name in mind, you can go ahead and put it on the contract. But if you want to ultimately put the title of the property in an entity name that you don't have yet, you can speak with your attorney about that, and we can put on the contract an entity to be formed, so that we don't need a definite entity at the time of the contract signing, so long as you have that entity name when you actually go to closing and accept the title to the deed. So in addition to deciding whose name goes on the contract, a consideration ultimately is whose name and how you want it to appear on the deed when you go to closing. So that doesn't always translate one-to-one, because on the contract, let's say, you may have a John Doe and a Jane Doe, but you don't specify the type of tenancy you ultimately want on the deed. On the deed, if you don't specify anything, the default is tenants in common, which means that if either parties, let's say there's party A and party B on the deed, if either party predeceases the other person, it would pass on to either A or B's heirs. That's the default, tenants in common. Now, if they specify it as tenants by the entirety, or joint tenants, then if either A or B predeceases the other, then the property would automatically go to the surviving party. So joint tenant is typically for a parent and child or sibling. Then you have some sort of established relationship there. So you understand that if either of the parties predeceases the other, it would go to the other party. Tenants by the entirety is very similar, but that's more reserved in the cases for a husband and wife. They're very similar in how they function, in the way that if either party predeceases the other, the party would go to the surviving party. However, there are some additional differences, including the rights of partition. So in investment property, you have the option to take title to the property either as an individual or as an entity, for example, an LLC or corporation. I do see with a lot of clients, especially if they own multiple properties, that it's very common to take title of an investment property as an LLC a lot of time for liability reasons and insurance purposes. So for example, if you were to default on the loan for one of your properties because that property's cash flow or the tenants aren't paying you rent and you're not able to keep up with the required covenants in the loan documents and make those loan payments, then that lender on that property would only have the right to foreclose on that property, because that's the only property that entity owns. But let's say you had that entity own a portfolio of properties, 5 or 6 properties, the economy for whatever reason takes a downturn, that property is underwater and you can't make payments on that property. When the bank forecloses on that property, the amount they sell it for at a foreclosure sale may not be enough to pay off what you actually owe the bank. Now your other properties that you also own are at risk now, whereas if your other properties are owned by different entities, you sort of shield yourself from that risk and liability. In a contract, you have a lot of times very basic information. You have the parties' names, the seller's names, who's in fee title, the purchaser's names, whoever is looking to purchase the property. You'll have the property address. You'll have the block and lot of the property. You'll have the Schedule A for a description. You'll have a description of the property a lot of times, which includes, for example, meets and bounds descriptions, something that's a bit more concrete so that they can identify the property. And then you'll have a lot of the terms that essentially guide the entirety of the transaction, how it is to proceed. And one of those that I know we'll want to talk about in a little bit is the down payment amount. So when we talk about down payments in terms of a contract, it's the amount typically we see as an industry custom, 10% of the purchase price. Let's say you're buying a property for $1 million, so then your down payment is going to be $100,000. This $100,000 down payment, or 10%, is due at the time of contract signing. and it's held by the seller attorney in their attorney escrow account. So as a purchaser, you're coming up with that money and you don't have to really be that concerned that, oh, this money is going directly to the seller. What if they run off with my money and don't sell me the property? No. When you come up with that 10%, once again, when you sign the contract, the seller's attorney is putting that money into their attorney escrow account, and they act as an escrow agent. Essentially, they make sure that both parties perform the obligation under the executed contract, so that if either party defaults, the contract guides what happens in an event of default, and then a down payment is dispersed accordingly. So for example, if you are the purchaser, you give your 10% down payment. In our example here is $100,000, and you can't close on the closing date, or the closing date comes around, you realize you don't have the funds that you thought you would have and you're unable to close. Then you go to the seller and say, look, sorry, I can't buy this property anymore, I need to cancel. But what happens then? The seller may now have waited 1 month, 2 months, even 3 months or more during a hot market period, and they may not be able to sell the property for what they thought they would have previously. So how do we compensate them for that? That 10% down payment is used as liquidated damages. So in this case, the purchaser would have defaulted under their obligations in the contract. The purchaser will lose that 10% down payment, and that 10% would go to the seller to sort of compensate them for that lost time that they should have been able to sell the property for, but they weren't.